Diolch o galon, Rodri. A very good afternoon to you, everyone, and thank you for turning up in such healthy numbers for this session today. It's very, very encouraging to see so many of you giving up your time to learn more about this significant decision by the Welsh Language Tribunal. In my view, it is the most important and significant decision that the tribunal has made to date. There have been some other decisions that are of note in recent years, but in terms of a decision that is likely to have a practical, real-life impact on the work that you need to do if you take interest in these matters or that if you have responsibilities for them, this is, in my judgment, without doubt, the decision that has the most far-reaching consequences and the one that needs to be at the top of your list in terms of decisions that you need to understand. I'm very grateful to Dan and Emyr for setting out some background matters. I'm going to focus today, everyone, on how practically you can take account of this decision and ensure that you're complying with your obligations under the standards in light of what the tribunal has told us now about how compliance should be achieved. And it seems to me that the decision has 7 main important implications, 7 main lessons, if you like, that we can draw from the decision in terms of our day-to-day work and how we go about considering effects or potential effects on the Welsh language when making policy decisions. And I say at the outset, although this particular decision was concerned with how to consider effects in a consultation document relating to a policy decision, the tribunal's decision is unquestionably relevant and will apply whenever the Welsh language standards impose a duty of consideration of effects. And what has the tribunal added to our understanding of what consideration means for this purpose? Well, this is the key takeaway, everyone. This is the new legal principle that has been established in the tribunal's decision. And this is not language that we'll find in the standards, but this is what the tribunal has concluded is implicit in those standards, which is that it's not just enough to consider Welsh language effects in a sort of a tick box way. There must be evidence of a conscientious effort made by the body that is subject to the standards to consider the possible potential effects on the Welsh language of the policy decision that is being contemplated. So we have clarity now from the tribunal that it's not just for the body, the public body in the first instance, to decide what must be done to consider the possible effects of the policy decision on the Welsh language. We're all familiar, aren't we, everyone, with when it comes to decision making by public bodies, the court will often say, well, it's for you, public body, to make the judgments, the decisions that you consider to be reasonable in this particular context, and provided that your decision is within the range of reasonable decisions open to you, then the court won't intervene with that and suggest that you should have done something differently. It's very important to understand in this context of an appeal to the tribunal being the ultimate stage that's available here. Very important to understand that we shouldn't be looking at compliance with these standards through a reasonable discretion lens. So we shouldn't be asking ourselves, provided we've come to a reasonable conclusion or in our judgment made a reasonable effort, it won't be for the commissioner to come to a different view. That's not the position in law, everyone, just to be clear now. The commissioner must make her own judgment if she's asked to investigate an alleged failure to comply with the relevant standards. She must come to her own judgment as to whether there has been a conscientious effort to comply with the relevant standards. And if there's subsequently an appeal to the tribunal will itself come to its own judgment as to whether there's been a conscientious effort. The tribunal won't just be looking at what the commissioner has said and concluding if that's reasonable, the tribunal will make its own independent judgment as to whether the evidence shows there have to have been a conscientious effort to comply with the standards. So what we are categorically moving away from, everyone, and what is certainly going to put you at legal risk, I would say, if you were to maintain this approach, is that it is no longer, as the Commissioner has already said at the start of today's session, it is no longer a tick box approach. We shouldn't be approaching these standards any longer on the basis of what's the minimum that we need to do to demonstrate compliance. The legal test now, as identified by the tribunal, is that there must be evidence of a conscientious effort to consider potential effects on the Welsh language. Now, I can almost hear you all say, well, what does that mean? You know, it's all very well to say conscientious effort, but what's that going to mean in one case that might be different from another? Well, the law, of course, is very familiar with needing to consider and apply tests that might require different things in different circumstances. So the second lesson that we get from this decision is that context, unsurprisingly, is key. There will be some cases where the conscientious effort to consider effects will require more from you because of the circumstances than another case might do. So to give you an example, a conscientious effort will require more of you as a public body if the policy decision in question relates to or is located within an area of sensitivity or significance for the Welsh language. And that sensitivity might be identified in one of the public body's own documents, in one of the local planning authorities' planning documents, might even be in the local education policy document. And that was the position in this particular case involving a school reorganisation proposal in Pontardawe. The tribunal rightly considered it highly relevant that the council's own documents identified the area in question as being an area of sensitivity for the Welsh language. And that therefore informed the tribunal's assessment of whether there had been a sufficiently conscientious effort to consider effects on the Welsh language. As the number and/or extent of the possible effects on the Welsh language increases, then clearly more will be required of you by way of a conscientious effort. There will be some cases in which there might not be an appreciable or conceivable impact at all on the Welsh language, particularly if you're perhaps a UK body that's making a decision in relation to an area of the country that's far from Wales or has no arguable Welsh language angle at all. There will be other cases where decisions will relate to policy decisions that go to the heart of how language is used, how it is promoted, how it is fostered in a particular part of Wales where there's sensitivity around language issues. Again, conscientious effort will require more depending on the circumstances. And as I've indicated, a key consideration will be to look at if there's any guidance or clue in any local policy or guidance, possibly in the planning context, possibly in the education context, that suggests that more is appropriate and necessary in order to demonstrate that conscientious effort that is proportionate to the importance of the Welsh language in the decision that is being taken. The third lesson, everyone, is the importance of having an eye to the potential mixture of effects. One of the difficulties that the council got into, I think in this particular case, is that it identified what it considered to be one positive effect of its proposed policy decision, and only one positive effect, and said, well, we can't really see any negative effects at all, but we'll come back to it and look at it again at a later stage. But there really wasn't a sense from the consultation document of any real attempt to identify the wealth of potential effects, be they positive, be they negative, or in some cases neutral. And you'll see that that language of positive or negative effects, of course, is reflected in the standards themselves. The standards themselves, when providing for policy-making standards, refers separately, to the importance of considering positive effects and how effects could be made more positive, and negative effects and how effects could be made less negative. So a key point of emphasis in this decision, everyone, is that it is necessary to consider the potential for there to be a range of effects that differ from positive to negative in character, and also potentially some neutral effects. One of the questions that comes up very often, everyone, in practice, and it comes up very often understandably in sessions such as these, is to say, well, okay, if that's where we stand, does that mean that we've got to identify every single conceivable effect that this policy will have, and therefore, if we fail to do so, we are at risk of breaching the relevant Welsh language standard? That is not the test. The tribunal and the commissioner before the tribunal has not sought to set an unrealistic standard here. There is not, I'm sure you'll be pleased to hear, there is not some magic list of a secret magic list of effects that the tribunal or the commissioner keeps up its sleeve, and then cross-checks what the council has done against this secret magic list, and then there's an instant fail if a single effect is not considered. Clearly, these are matters of judgment, and so there will need to be judgments exercised, and it's not necessarily the case that there is a single right answer in terms of all the possible effects that need to be considered. But what the tribunal has said is that at a minimum, what is required is a conscientious effort to try to identify the full range of potential effects. And provided that that conscientious effort is made, then you are very unlikely to be at risk of a standards breach if it might be said against you that there was one particular type of effect that you failed, in inverted commas, to consider. You are much more likely, everyone, to meet that standard of demonstrating a conscientious effort if you really have separately tried to identify positive effects, negative effects, neutral effects, and then, as I say, assess those in the round. And I'll come back to how we might start to do that in practice imminently. Lesson number 4, everyone, from the decision: general factual statements about what the body is doing to try to promote or facilitate the use of the Welsh language are inadequate. One of the arguments that the council made in this case was to say, well, look, in terms of our compliance with the standard of giving consideration to effects, look at what we're doing generally in relation to the Welsh language in education. They said, look, we've invested heavily in Welsh medium schools. We've supplemented those recent investments recently. So the argument was essentially, look at the bigger picture. If your complaint is about this particular decision, well, you've also got to take account more widely, the council was arguing, look more widely at what else we're doing, surely as part of your overall assessment of the regard that we're having to Welsh language matters. And the tribunal and the commissioner before the tribunal was very clear about that, in saying that general factual statements about what the council might be doing very positively, very constructively, generally, it does not equate to considering the possible effects of the particular proposed policy decision on the Welsh language. So if there has not been a conscientious effort to focus on the particular effects or possible effects of the policy decision that is being contemplated, the body will not be saved by trying to point to other things that it might be doing constructively to support the Welsh language elsewhere. General factual statements are not going to be sufficient, everyone, to ensure compliance with the standards. Lesson number 5 is that the consultation report will not come to the rescue if the consultation document is sufficient. Now, let me be clear about what I mean by that, because different bodies can use different labels for these sorts of documents. But for the most part, most public bodies, when they're engaging in consultation, will prepare something called a consultation document. And that's the document that's prepared at the start of the consultation process to tell people about what the body wants to consult about, to say a little about the proposed decision, and to set out all the evidence that the public body has prepared to assess the potential or likely effects of that particular policy decision. And then the consultation report is different from the consultation document in that the consultation report is something that comes after the consultation period. And then the clues in the title, it's a report that reports back on what people have said, consultees, during the consultation, and then giving usually a steer as to where the decision making for the public body is going on from there, in light of what people have said in the consultation. Key point, everyone, to get from this decision is that if your consultation document doesn't comply with the standards, you will not be rescued if by arguing, well, the consultation report, which came later in the process, plugged the gap and considered the effects at a later stage. It is not possible to rely on post-consultation analysis or discussion in a consultation report to try to demonstrate that there's been compliance with the standards in relation to the consultation document. Or, everyone, to put it in a different way, what the tribunal has confirmed is that when standards 91 to 93 refer to the consultation document, that should not be interpreted as including the consultation report. The consultation document is categorically the pre-consultation document. Lesson number 6, the formative stage of decision-making will not excuse an inadequate assessment or inadequate consideration. Now, what do I mean by that? As we know, those of you who will be very familiar with consultation will know, of course, that consultation will take place at a stage in the overall decision-making process when the decision-making is at a formative stage. In other words, there's no point going out to consultation if you've already made your mind up. You are still contemplating the decision, you're at the formative stage of moving towards a decision, so therefore it makes sense to consult on it before you move on to the next stage. Now, what the council said here was, well, look, given that we're at the formative stage here when we are preparing our consultation document, indeed the law requires us not to prejudge matters and to be at a formative stage when we're preparing a consultation document. Given that we have to be at a formative stage, then surely you've got to take that into account when you are looking at our Welsh language impact assessment, because surely necessarily, therefore, the Welsh language impact assessment also has to be a formative document that is going to be become a more sophisticated document as the process proceeds post-consultation. And the tribunal, and again the commissioner before the tribunal, said no, that's not the right approach. Yes, a consultation must take place at a formative stage, but that does not mean that your Welsh language impact assessment can be a formative document or a document that is only covering matters in a very basic or preliminary way. And when you think about it, that makes sense, because of course, if you've got standards that are focused on the consultation document, it's illogical, of course, to wait until the end of the consultation period before you seek to comply fully with those standards in relation to a consultation document that has long since been published and you've already had the consultation. So it will not be an answer to say, well, we are at an early stage of our thinking, so therefore we would like you, the public, to tell us what you think the likely effects of this policy decision will be on the Welsh language. In other words, there has, and in fairness to the council, they certainly haven't been alone in this as a practice in Wales. I've seen many examples of this over the years, where, to be blunt about it, the public body will expect the public to do the heavy lifting during the consultation period when it comes to identifying possible effects on the Welsh language. Now, if we just reflect on that for a moment, everyone, we wouldn't really do that, would we, in any other context? Those of you who will be familiar with planning decision making or environmental decision making, we would never say to the public, look, we would like to build this large building, and we're going to go out to consultation, and we'd like you to tell us what the likely environmental effects of our proposal are going to be. That's not the position. That's not what law and policy requires. Law and policy is at a stage where the person who wants to do the act in question, whether in that example, to erect a large building, the person who wants to do that has got to do the heavy lifting in terms of assessing the likely effects of that proposal in environmental terms. And unfortunately, possibly due to the lack of a clear standards before the standards regime was introduced, that's not tended to be the approach when it comes to Welsh language matters. And there's definitely been a trend, I would say, over the years of public bodies saying, you tell us what the effects are. The tribunal has now emphatically said that is not the right approach. Just as is the case with any other area of policy making, the tribunal has said that the person who wants to make that policy decision, here the public body, it's for that public body to identify the likely effects of that policy proposal and to set those out in the consultation document. And of course, people can be asked to the public can be asked to supplement their views and to comment on those effects as identified. But that should be on the basis of the public body having done the work itself first to identify those likely effects. And that, unfortunately, is not what happened in this case. And the final lesson, everyone, to take away from the decision is the virtual certainty that you will need to revamp internal guidance that you may have on Welsh language considerations if you want to mitigate the risk of being found to be in breach of those standards. Now, what do I mean by that? Again, if you were to look across Wales at bodies that have published internal guidance about how to deal with Welsh language considerations in decision making, a very common type of document that I've come across when I've been working on these cases is an internal guidance note or a briefing that really does no more than quote the standards or summarize or paraphrase them and essentially say, look, you just need to think about this when you're making a decision. That if that advice or that type of advice, high-level advice, were followed now, it would be very likely to lead to a standards breach in light of the tribunal's decision. It is inadequate simply to issue guidance saying these are the standards and you've got to consider them. Because this is a new principle of law established by the tribunal in the decision, it is highly advisable, everyone, that if you've got internal guidance on Welsh language considerations in decision making, that the internal guidance at a minimum should refer explicitly to this legal requirement now to make a conscientious effort to consider the possible effects, and that a tick box approach will not do. And what I would suggest doing in addition to that is to include case studies in internal guidance showing how it can be demonstrated that a conscientious effort has been made. The council might have its own or the public body might have its own examples of decision making in its own area that it might want to include in as such a case study. It might want to draw from examples from the education planning context as relevant. It'll depend on the particular body's area of interest, of course, but it would be prudent, I think, for public bodies to think in advance in internal guidance publications as to what conscientious effort is likely to, how is that likely to look for decision making by your particular public body, and giving, as I say, an example or a case study as to how the standards can be complied with, and this test of conscientious effort can be complied with, would, I think, be highly, highly advisable. So those are the 7 lessons, everyone, that I certainly draw from the decision and will be applying in my own practice when I deal with these standards in future. I've then thought about, well, how, in addition to those 7 lessons, how can I try to be even more practical in the advice that I'm giving you as to how we can start today, all of us, to make a start on ensuring that we're complying with these standards and this test of conscientious effort appropriately. And it seems to me that there are 5 top tips that I would give you as a starting point for how to start now on this new chapter and this new important work. The first tip is that, in my view, the age of, or the era of, treating Welsh language effects under a single headline in what's often called an integrated impact assessment, and you'll be familiar, many of you, I'm sure, with what that means. It's the type of impact assessment where we consider public sector equality, duties, human rights considerations, other Equality Act considerations, and so forth. The trend has been generally to include Welsh language effects and the consideration of them in that sort of overarching document. That is not necessarily in principle unlawful or inadequate to comply with the standards, if, of course, what is contained in the integrated impact assessment still meets that test of a conscientious effort. But in my judgment, everyone, you're unlikely, and it's not really the most helpful starting point if you're trying to fit this new requirement to comply with a conscientious effort within that sort of format. Because for good or ill, I think there is a sense in which, you know, that format of an integrated impact assessment has something of a secondary status compared to, let's say, an environmental impact assessment, where you would never dream of considering environmental effects, let's say, in an integrated impact assessment, because the law and policy is such that they warrant their own document in a separate standalone document. I think, given where we are now in light of the Tribunal's decision, the time has come to pull out Welsh language effects from that integrated impact assessment and to do a separate standalone assessment in order to demonstrate or be more likely to demonstrate that that conscientious effort has been undertaken. A second and related tip is that I think we need to move away from this oversimplistic approach that we have in some cases of trying to identify what's called the net ultimate effect on the Welsh language. And again, I use the environmental context as an example. In the environmental context, we are well used now to saying, well, look, a decision might have positive air quality effects. It might have, you know, really negative noise effects, let's say. But those effects are simply too different in kind to balance them against each other and try to come up with some overall judgment as to whether the proposal is good or bad, positive or negative for the environment. You know, the better approach is just to say it would have positive effects for air quality, negative effects in terms of sound, and we just need to consider those, that richness of effects, if you like, in the assessment. I think we're now at that point, in light of the Tribunal's decision, where we need to do the same in relation to Welsh language impact considerations. So it's no longer a case of saying, well, we have these positive effects, we have these negative effects. So where are we when we put all of those into the wash? Are we in a good or a bad place when it comes to the Welsh language? That won't do for the standards now. The standards distinguish very clearly between positive effects and negative effects and require them to be treated separately. And this previous practice by some bodies of trying to identify a net effect, which is really a function often of the integrated impact assessment, it is really not now an approach that I would advise be taken, because it's likely that you'll end up having an overly simplistic approach that will fail to demonstrate that compliance with that conscientious test. If you were to ask me, well, okay, how do we start on this work? I would say that as a starting point, and this is only a starting point, if you want to ensure that you're getting off, on the right foot when it comes to what the sort of thing that the tribunal is thinking about, think really openly at the start, openly, objectively, and transparently. Have 2 columns on a page or on a computer or whatever, and have a column for direct effects and a column for indirect effects. And in both of those columns, try to identify, just as an exercise to get the process going, try to identify at least 3 positive effects and 3 negative effects. You might struggle to do that in some cases, and that's fine. If so, say that, say that, you've given very detailed consideration, but, you're unable to identify, let's say, more than 2 positive effects. If that's a reasonable conclusion and you can justify it, then that's likely to be sufficient. But the reality is, as we know from decision making, most decisions are likely to have a mix of positive and negative effects, and they're likely to have a fair number of positive and negative effects. Just to ensure that you don't fall into the trap of saying, oh, I've identified 1 positive effect, that's the end of it, and I'm satisfied there won't be any negative effects at all, which is really, a red light straight away that the exercise is likely to be superficial. As a discipline, just try to think in the first instance of 3 positives, 3 negatives, and then you can use that as your starting point for then, in particular, standards 92 and 93, considering how those effects that you've identified could be made more positive, how those negative effects could be made less negative. And finally, everyone, and this is almost a catch-all for all of the tips in the list, take ownership of the Welsh language impact assessment. If there's one message that comes out of this tribunal decision more than any other, it's that the public body must take ownership of the Welsh language impact assessment and not just see it as something that you bat away to the public to do all of the legwork, and then the public body picks up what people have said in the consultation report. It's your assessment. It's your assessment to get right in terms of meeting the legal standard of conscientious consideration. So be conscious from the outset that it's your own document, and it's one, as I say, that you need to take pride in and ensure that it, as with all assessments for decision making, it's an assessment that really does contribute meaningfully to the decisions that you're making. And that, everyone, completes my presentation. I hope that that's been helpful. Diolch o galon.